from the State's Commission office. He will be answering any questions. This is a first for Lakeville. I've been trying to get this for the past 8 years, but thank you for coming and telling us what we should and should not be doing. So,
well, I don't know that I'm going to tell anyone what they should not be doing,
but you can guide us.
I'll explain what our legal
Thank you.
requirements are under
Thank
the
you.
law, and you can make your own decisions. Thank you
Thank you so
for
much.
organizing this. So if you find that this is an exciting presentation and you've got nothing better to do, second show is at 6 o'clock, providing we get a good turnout. So we got a good one for this. My name is David Giannotti. I'm with the State Ethics Commission, and we're going to talk about the conflict of interest law. Now, the conflict law is fairly complicated in some sections if you have any familiarity with it, and I hope you all do, because we have statutory requirements that we all have to complete on the conflict of interest law, the online training program and the summary of the law and so forth. I'm going to try to explain it in hopefully a more consumable way. And since I'm here, it's a great opportunity to ask questions. And I'll, if there's anything that's been confusing you, I'll do my best. Now, a couple of ground rules: I'm not a lawyer, so I don't give out legal advice. I can't tell you specifically what you need to do to comply with the law. I can explain the law generally, hopefully in a way that will give you wink, wink, nod, nod, an understanding of what is required in a given situation. Also, with any questions, and I encourage questions because they help liven up the discussion at some points. You can disagree, you can have commentary, and it'll make the discussion lively, or you can listen to me go on for the better part of 2 hours, and I'll do my best to fill the time. I haven't had any problem yet. But with a question, don't tell me you violated the conflict of interest law. That's a no-no. So keep any question hypothetical or prospective, okay? And I'll help guide you through that process if I feel we're going astray. So it looks like we've got 20 people who have joined remotely, and welcome everyone who's joining remotely. Thank you for taking the time to participate in a conflict of interest law seminar. For those of you who think that this is a substitute for the online training program, I've got bad news for you. It is not. This is an add-on seminar, but you still have to complete the online training program. Usually I get about 4 people get up and walk out. Okay. In any event, for those of you who have joined remotely, we will be monitoring the chat, but if you have any questions, keep your microphones muted during the presentation. But if you have any questions, unmute your mic and just say, "I have a question." And that'll prompt me to stop, and we'll take on those questions as well. You may not have a question, but if you do, don't be afraid to ask a question. Now, on the first slide here, as we go into the presentation, you'll see my contact information. For those of you who might be a little intimidated and not really comfortable asking a question in this forum, you can contact me in the office or on my cell or by email, and I'll do my best to explain the law. You can reach out to me offline, and we'll continue that kind of a discussion. So what's it all about? Well, we are public employees. How many of us are board members? How many of us are department employees, like full-time? Okay, so we got a mix here, and I'm sure it's reflected with the remote group as well. So some of us are board members, some of us are department employees. You are all town employees for conflict law purposes. And under the law, the conflict of interest law is one of those statutes designed to maintain confidence in government, one of those good government kinds of laws. It deals with specific conflicts of interest. And a conflict of interest is any situation when you're poised to perform your duties as a town employee and your private interests are also going to be affected by what you do. Now, what's a private interest for conflict law purposes? Well, it's any significant component of your private life, not policy biases, but the tangible components of your private life, the people and the entities, organizations, businesses, you name it, that you affiliate with when you're not at work. When you are performing your town responsibilities and some component of your private life is going to be affected by what you do, that's a conflict of interest. What is a private interest that rises to the level of a conflict? Well, who you are, who your family members are, what outside business interests you might have, what outside property holdings, business interests, are you privately employed? Do you own or operate a business? What church you might affiliate with. Sometimes matters affecting private, nonprofit, charitable groups have to be decided by town boards or town departments. And if you're poised to perform your duties and some component of your private life will be affected, that's a conflict. It doesn't mean it's a violation of the law, but it does mean that the conflict law applies, because as a general rule, the conflict law says when we're performing our town responsibilities, we're required to serve the public interest. And conflicts of interest can undermine confidence in government, because the public looking at those kinds of situations will become concerned. Is that public employee serving the public interest the way they're supposed to? Or are they making decisions to favor some component of their private life? In other words, has their decision-making been altered? Could they be improperly influenced in how they do their job, because what they will do will affect some component of their private life? And so those are the situations that the conflict law is designed to restrict. The conflict law imposes restrictions on what we can do if we encounter a conflict of interest. Now, when you're talking about your day-to-day work as a board member, it's, week to week or evening to evening or what have you, but generally in your day-to-day work as a town employee, conflicts basically fall into one of two buckets: financial interest conflicts and everything else. A financial interest conflict falls under the section we refer to as the nepotism section. Nepotism and self-dealing. And the compliance rule is, you're out, you're disqualified. You cannot perform your town duties if what you will do will affect your own financial interests or the financial interests of certain family members or businesses that you affiliate with off the job. Nepotism and self-dealing. Now, there are workarounds. I'm going to talk about the restrictions that the conflict law imposes, but where there's also a workaround, I'll explain that as best I can as well. But that's sort of bucket one, financial interest conflicts. The terms we use to reflect a compliance with the nepotism section are abstain and recuse. And those two terms mean the same thing in our world, although they might have a different meaning in a different context. But basically, it's the public employee is stepping back from something they would ordinarily handle, because the matter will affect their financial interest or others that fall within the definition. So that's bucket one. Bucket two covers basically everything else. All other types of conflicts of interest that don't feature a financial interest component. The most common type of conflict that occurs in that category are what we call appearances of conflict of interest. Now, an appearance of a conflict is not an actual conflict. It is merely a circumstance. You're poised to perform your duties. Some component of your private life is going to be affected by what you do, but there's no financial interest impact. And those circumstances create an appearance of a conflict because, again, we're required to serve the public interest, and the public, looking at how the public's business is being conducted, will become concerned. Is that person serving the public interest? Are they doing their job the way they're supposed to? Or have they been influenced because the matter affects some component of their private life? For those types of conflicts, the law doesn't require us to step back. It allows us to continue to do our job, provided that we put the cards on the table first. The conflict law requires transparency. As a general rule, public employees cannot perform their duties with any hidden or undisclosed biases. And when I talk about outside interest, I'm saying private interest, outside interest, biases. Basically, that's what a conflict is. You have biases. You're favorably predisposed towards your biases. Who you are, who your friends are, who your family members are, what businesses that you affiliate with, what nonprofits or other business entities you might affiliate with. Those are your biases. And whenever a bias is affected when you're performing your town responsibilities, think conflict of interest. This presentation is not going to make you an expert on the law, by any stretch, because there are 29 different sections of the law. And you'll find some of them are fairly intuitive, but others anything but. All that we want to do, in addition to the online training program and whatever other exposure you've had to the law, is just to get you to better understand when the red flag needs to go up. And then once the red flag goes up, don't do anything until you understand what the compliance rules are. And then follow the rules. And what I'm going to constantly underscore is don't guess. Because what happens if you guess and guess wrong? The Ethics Commission can enforce the conflict of interest law and can impose civil penalties of up to $10,000 for a significant violation. We want to avoid all of that. We want to avoid all of that by giving you the information you need so that you can better understand and comply with the conflict of interest law. Now, when I say that we enforce the law, that's not meant to scare you. We only do that infrequently. We get and we review 700 to 1,100 complaints every year, and our enforcement teams review every one of them. But our commission only takes public enforcement action where it imposes a fine. And I say fine, that's a loose term. It's really a civil penalty. We operate under the rules of civil administrative procedure, we don't enforce the law criminally, so there are no fines, there are civil penalties. But the commission only takes enforcement action in about a dozen to 2 dozen cases in a year, out of 700 to 1,100 complaints that we receive every year. So, as you know, it's a small percentage. The commission will only take enforcement action in cases where there are egregious violations of the conflict law, where there's some, willful misconduct, unlawful self-dealing, or some egregious conduct where there's a conflict violation that underpins that. That's when the commission will take enforcement action. But for everything else, it stays under the radar. We are required by law to operate in secret. What that means is, one of the things, my team is the public education and communications team. So, we manage our website, we take press calls, we issue press releases, all that kind of stuff. And we get calls from reporters or the public all the time asking, did you get this complaint? Are you investigating such and such? This person said they got advice from you. Can you confirm that? And our answer to all of those is, we can neither confirm nor deny. We have strict statutory requirements that say we can't talk about stuff we're looking at, whether we've received a complaint, whether we're investigating any matters, or whether you or me or anyone else has called the commission for advice and what, if any, advice was provided. The only exceptions to that are in an enforcement context is when the commission takes enforcement action, when it exercises its authority. Then the decision of the commission in an enforcement case is public. Everything leading up to that is required by law to be kept confidential. So, public responsibilities, private interests, when there's an intersection, red flag needs to go up. Think conflict of interest. And then if you're not sure whether the law applies, and if the law does apply, how, you call our office. I can't give advice, but we've got attorneys on staff who do. And one of the most important services we provide to you and all other of the approximately 400,000 public employees in Massachusetts is free, confidential legal advice. And I say confidential because we can't confirm whether you called our office. We can't confirm whether we provided you with any advice. And in terms of complaints, we are required by law to keep complainant identities confidential. But we're probably one of the few government agencies that still accepts anonymous complaints. We don't care, where the information comes from, and we understand that people might not have pure motives when they call us to make complaints. It's our job to decide what are the facts. We get information and we then take steps to corroborate the facts that we have, and with an eye towards, has the law been violated, and if so, is it a significant violation? And there's a continuum that we use. So that's basically Conflict Law 101. So we have the State Ethics Commission. It's a 5-member commission, and those members are appointed by the governor, the Secretary of State, and the Attorney General. The governor makes 3 appointments, and the AG and the Secretary each make 1 appointment. Our commissioners serve 5-year terms. They're unpaid for that service, and they are ineligible for reappointment. It's designed to keep the agency independent and free from any sort of outside interference. And the job of the commission is to administer and enforce the conflict of interest law. There's another statute, called the financial disclosure law that applies to state and county, certain state and county employees, the policymakers who are appointed state and county employees, and then all of our elected officials, the legislators, the constitutional officers. In addition to complying with the conflict law, they are required to file financial statements with the Ethics Commission every year, and that's to comply with the financial disclosure law. So the conflict law is cited as Mass General Laws, Chapter 268A. The financial disclosure law is cited as Mass General Laws, Chapter 268B. Everyone who's performing services for a state, county, or municipal agency is required to comply with the conflict law. It doesn't matter whether you're paid or unpaid. It doesn't matter whether you are elected or appointed, and it doesn't matter whether you're full-time or part-time. All that matters is, are you performing services for the town? And if the answer is yes, then you are a town employee for conflict law purposes, if for no others. And that means that all of the board members, you're serving as citizen volunteers, and thank you for that. It's important work that you do, but it is important work that you're doing. And so even though you consider yourself a volunteer and you are unpaid for the most part, you are still a municipal employee for conflict of interest law purposes. The law also reaches vendors, and we haven't been very good at providing information. We're going to start to improve on that to remind public agencies that if you have a vendor contract with an entity, and there are specific people within that entity whose services are required to satisfy a contract with the town, they become town employees as well for conflict law purposes. And the point of that is, when you notify town employees to complete the education requirements every year, the vendors have to be included. Not all vendors, only the key people in the contract. Are their services specifically mentioned in the contract? Has their resume been provided as part of the point of the contract for their bid? Do they own the company? What have you? If the town contracts with a private bus company, the bus drivers don't become town employees. But the president of the company or whoever is the point person for that bus company in dealing with the town and administering the contract, they become public employees. Okay, the services we provide, well, we're here. That's one of the services. We do educational services. But the most important one is the legal advice. We have attorneys on staff available to provide you, me, and everyone else who's subject to the law with free confidential legal advice. We get over 6,000 calls a year from public employees, so don't be afraid to call us. Everybody else does. We're on the speed dial of a lot of our legislators because they're always getting invited to events. There's a meal being provided. I'm being given an award. There's a ticket needed to get into this event, but I'm being given free admission. All of those things that can implicate the conflict law. And so they're calling us on a regular basis, and so we encourage everyone. Don't guess. You might guess wrong. Call, and we'll be happy to explain how the law applies. In other words, think of us as like a law library, or think of us as a resource for you. You've got enough to deal with the services you're providing to the town. You don't have to be an expert on the law. That's our job. You just need to know to call us. Don't guess on it and don't be afraid to call us. The biggest problem that we sometimes face when we're doing investigations is people who violate the law. And they do so willfully because they think it's no big deal or that nobody's going to find out about it. Don't make those assumptions. When you're talking about conflicts of interest, understand they happen every day in government. They may never happen to you, but they happen every day. And they're not to be feared. They're to be managed. You manage them by getting out in front. Don't think that it's not a big deal or somebody's not going to find out, because we've got enough cases where people who made that assumption guessed wrong. Whether something is a big deal or not is not a decision you're going to make when it comes to your own conduct. It's going to be other people who will decide whether what you did was a big deal or not. And don't assume that nobody's going to find out, because what happens when they do and it reaches our level? You just want to make sure everything is above board and that your reputations are intact and that the services you're providing for the town are always in the public interest. That's what it's all about. So we conduct these seminars, you get legal advice, free confidential legal advice, you can call us, you can write to us, we have a fillable form on our website. Reach out to us, we have attorneys on rotation, the attorney we refer to as the attorney of the day is the particular attorney on rotation, and we're very proud of the fact that we return calls very quickly. Most cases, calls are returned the same day, if not the day after. You know, we get compliments all the time that, you know, geez, you're a state agency and you had somebody pick up the phone. Yeah, that's our job. We can't help you if we're not picking up the phone. So it's not a voicemail system when you're hitting all these buttons and in the very end, you're leaving frustrated. At least that's my experience with other state agencies. We want to be there, and we are there, and we will return the call. So please call us. And since we enforce the statute as well, we have prosecutors and investigators on staff, and they vet all of the complaints. They intake and vet all the complaints that come in, and they make determinations about whether something is within our jurisdiction and if it might implicate the law, is it a serious violation? And then everything goes up from, you know, initial review, inquiry, commission action, commission decision. Yes?
This one?
Okay. Oh. That's, okay. Yeah, I'm, all right, I was just talking about the third bullet point down there about filing a complaint. So legal advice. So say you have encounter a conflict of interest. Red flag has gone up and now you need to know what to do about it. You call our office, ask to speak to the attorney of the day. Now, you won't talk to that person right away because of the number of calls we get in. We've got 6,000 calls and 6 attorneys to handle those calls. So you do the math and they're pretty busy. So all calls go in through reception, where the receptionist will obtain information about who you are and the nature of your call, just to tee it up for the attorney, so that when they can call you back, you know, they're informed about the nature of your call. It makes it more efficient for them. But you can call, write, whatever. The second to last bullet point there, that's the important stuff. We don't give out third-party advice because we're required to keep matters confidential. In other words, we'll talk to you about how the conflict law applies to you. We can't tell you how it applies to someone else. We would say, hey, they need to call us to find out how the law might apply to them. The exception is if we have somebody's express permission for you to obtain advice on their behalf, we'll go ahead and do that. But we would need express permission. Also, we don't give out past conduct advice. It's all about getting out in front and managing conflicts. Our legal division can only give advice about your prospective conduct. If you decide to engage in any conduct that implicates the law, and then you want to try to call our office and get an opinion from our legal division, you'll be disappointed, because once it becomes a past conduct situation, it's no longer within our legal division's purview. It then falls to our enforcement division's purview. They get to decide whether what you did violated the law, or they'll move that along. The commission ultimately makes those decisions. But the legal division can only assist you if you contact them before you engage in any conduct that might implicate the law. And again, it's all about managing conflicts by getting out in front. You know, if a red flag goes up because you have a conflict, don't do anything until you understand what the compliance rules are. And that might mean calling our office and talking to the legal division. You do all of that in advance. Okay, we have a website. If anyone is interested in learning more about the law and they're nervous about talking to us, although I don't know why you would be, because we're all friendly people, but you can go on our website and we have some useful information to explain the conflict law. It's not a very deep site because we can't talk about most of the work we do, but what we can talk about is up on our website. We have certain educational materials that might explain the conflict law either by topic, political activity, for example, or by public position, how the law applies to planning board members, for example. We have certain legal opinions that we can post. Any opinion that's deemed to be precedent, like the first pass the commission has made on a given fact situation. Those opinions are approved by the full commission as opposed to issued by our legal division attorneys. Our legal division they give advice based on past commission precedent. So they need that precedent to inform them on how to give advice. So if an opinion is deemed to be precedent, it first goes to the commission for approval. We can post those opinions as long as we can redact the requester's information. Our enforcement decisions, once the commission decides an enforcement matter is public, posted on our website. Disclosure forms, putting the cards on the table. The conflict law requires transparency. As I said, we cannot perform our duties with any hidden or undisclosed biases, and so there may be occasions where the law allows us to do our job even though we have a conflict, but at a minimum, we're going to have to disclose that conflict, and we're going to have to do it in a public way. Transparency is required to help maintain confidence in government. When we put the cards on the table before we engage in any act where we have a conflict, that serves to dispel any appearance problem that's otherwise created. And then links to the mandatory resources. Now, you've all, presumably, taken the online training program. We're launching a new program very shortly. If my vendor doesn't continue to drive me crazy with delays, we should have had this thing out there already, but we're going to try to make it easier for everyone to complete the conflict law, eliminate the requirement to print out or save a completion certificate. We're using our own LMS so that the town, if they sign up for it, you can all register to use the LMS, and then you can complete the conflict law, the new online training program, and then it automatically generates completion certificates. It stores them in the database, so nobody has to chase you down for a completion certificate. They just have to go into the database and they'll see that you've completed the program or downloaded the summary of the law so that an acknowledgement is there. But links to all of that stuff are also available on our website. So conflict law disclosures, transparency. It has to be in writing. You just can't tell someone, oh, I know so-and-so, because then that all disappears into the ether. To comply with the conflict of interest law, when you're participating in your business as a town employee and you have a conflict and the law allows you to continue to do your job, provided that you disclose the conflict, it's got to be in writing. So on the slide is a representation of what a disclosure form looks like. We have disclosure forms depending on which section of the conflict of interest law or whether a regulation might apply to a situation. So if you encounter a situation and you need to see whether there's a disclosure form that you need to file, they're available up on our website. But a conflict law disclosure to comply with the law has to be in writing. It has to contain all of the facts that constitute your conflict, your bias. And it could be just as simple as, I serve on the planning board, and so-and-so is coming before the board for an approval not required application. And it's my friend. It's my neighbor. It's a coworker. It's a family member, but it's not something that affects their financial interest. The law allows me to continue to participate in that A&R, provided that I file a disclosure that I know that person, that I am a planning board member. The board will be poised to approve an A&R at this particular address, and the applicant is so-and-so, whom I am acquainted with. How? That kind of stuff. All the relevant facts. Yep. Oh.
Try to stay close. I'll be quite thick because people at home lost a little bit there when you step way back.
Okay. Usually my voice carries. Maybe not today. Okay. So the disclosures have to be in writing. They have to contain all the relevant facts. You don't get to leave something out because you think it's embarrassing. A disclosure that doesn't contain all the relevant facts that constitute a bias does not comply with the conflict of interest law. It's imperfect. And so where do we file disclosures? Well, it depends on whether we're appointed or elected in our particular position. If we are appointed, then we would file a conflict law disclosure with whomever appointed us to our particular position. It could be the town administrator, town manager, or it could be a department head, or what have you. If you work for the school department, it could be the school superintendent, or it could be the school committee, it could be the board of selectmen. So I work for the Ethics Commission, I'm on staff. My appointing authority is the commission's executive director. The executive director's appointing authority is the full commission. The appointing authority for any one of the 5 commissioners depends on who appointed them to the commission. Was it the governor, the secretary of state, or the attorney general? So for your purposes, how did you become a town employee? Were you elected to a town office, or were you appointed by someone to the position you hold? If you were appointed by someone and you have a conflict that where a disclosure is required in order for you to perform your duties, you would file it with your appointing authority. If you are elected to a town office, you don't have an appointing authority. And so we advise elected office holders to file a conflict law disclosure with the town clerk's office. It's filed in a manner that is public in nature. These are public records. You are performing the public's business. There is a record of how the public's business is being conducted. For board members, you keep the minutes of your meetings, and those meetings are then approved and published. And so if a public employee participating in the public's business has a bias, has a conflict, that has to be disclosed in writing, and it becomes part of the public record. Those have to be saved for a period of 6 years to comply with public records law requirements. Okay, let's talk about the conflict law. Any questions before we dive in? Okay, you're absorbing all of this information like sponges. Let's talk about the conflict law by topic. The first being the gift restriction rules. The question being, can you accept a gift from someone? And the answer to that exciting question is, it depends on the circumstances. As a general rule, if your public position is influenced or implicated by anyone providing you with a gift, and when I say gift, I'm not talking about something in a box wrapped with a bow. It could be that. But I'm talking about any item of value where there isn't something given in return of equal value. An item of value given to a public employee. And if it's because they are a public employee, red flag needs to go up. This stuff can get tricky. The restrictions are identified on the slide through the bullet points. And when I talked about some of this stuff being intuitive, the top bullet point is one of those, bribes. A bribe is a corrupt act. It involves some item of value being given to a town employee to effect a specific result that the person offering the bribe does not ordinarily qualify for. A bribe is a corrupt act because it involves a quid pro quo. And that just means there's an exchange. I give you this, you give me that. In a bribe situation, there is an explicit understanding that the gift or some item of value is given with a string attached. The other restrictions is a gift given with no string attached, but in a bribe, there's a string attached. Easy example. So I'm coming down to the town to do this seminar, and I'm tooling down 24, and everybody's aggravating me because it's bumper to bumper traffic. I see a little opening, so I take advantage of that. I goose it, and all of a sudden I'm doing 90 miles an hour down Route 24. Now, what's the speed limit on 24? 65. What happens if I get stopped by a trooper going 90 in a 65? What's the chances I'm going to get a ticket? About 100%. What happens when I'm asked to produce my license and registration and I don't say anything, but I tuck a $100 bill in between my license and registration and I don't say anything? Everybody knows what the purpose of that is, quid pro quo. Where the trooper would issue a citation 10 out of 10 times for someone going 90 in a 65. That $100 bill is designed to get them to not write a citation in a situation where they ordinarily would. The normal rules go out the window. So a bribe is a corrupt act because it's intended to corrupt the public's business, the public process. Because bribes involve corruption, it's the worst violation under the conflict law, and the commission can impose a civil penalty of up to $25,000 for a violation of that section, where for all other sections, it's up to $10,000. And both parties can violate the conflict law, not just the public employee. And the bribe doesn't have to be given. The mere offer of a bribe to a public employee, the mere solicitation by a public employee of a bribe is sufficient to trigger a violation. The middle bullet point deals with what we call illegal gifts and gratuities. And that's where the $50 rule first appears. It appears in 2 sections under the law. But in the gift restriction section, it says that it's a violation for anyone to offer or give to a public employee or for a public employee to solicit or receive any item worth $50 or more that is given by someone with whom the public employee has official business dealings. The statutory language is given for or because of some official act performed and to be performed. That doesn't mean there's a quid pro quo. It merely means that there's a business connection. The public employee has some business dealings going on with the gift giver. $50 or more is prohibited. Both people can violate the conflict law, and again, it doesn't have to be conveyed. The mere offer is sufficient to trigger a violation. But that's where the $50 rule applies. Now, that means that it establishes a gift threshold. $50 or more, prohibited. Less than $50, we'll talk about it. The bottom bullet point is sort of the threshold gift restriction rule, I should say. It takes out the business nexus. It just ties in your public position there, and that's the general rule under the conflict law. If your public position is implicated in any way, shape, or form with somebody providing you with a gift, some item of value, red flag needs to go up. And then the continuum. Is there a quid pro quo? If not, is it worth $50 or more? Is it given to me by somebody with whom I'm having business dealings with as a public employee, or is it given to me just because of my public position? Public employees cannot accept items of value valued at $50 or more that are given to them because of who they are as public employees. Any questions on that? Yes?
Just for clarification, is it $50 per event or $50 per year?
Well, $50, the law says if it's $50 or more, it can't be accepted. So it doesn't matter whether it's per event or over a course of time. It's still prohibited if it's $50 or more. What you're referring to is what we'll get to right now. What about, before we get there. At the bottom of the slide, you see a reference to an advisory, 19-1. If you have any questions on the gift restriction rules, you may want to go to our website, review that advisory, and then if you have any questions, specific questions, you can call us and we'll help explain it further. So let's now talk about gifts that are not worth $50 or more, because that's the threshold. And for bribe purposes, the quid pro quo, there's no minimum value. Technically somebody could bribe someone with a stick of gum. Of course, that's ludicrous, but any item of value conveyed to a public employee or offered to a public employee where there is a quid pro quo, that's problematic. Doesn't matter how much. For the illegal gifts and gratuities, it does matter how much. Anything worth $50 or more is prohibited if given by somebody with whom the public employee has official business dealings or given to the public employee because of who they are as a public employee. Gifts worth less than $50 are not prohibited, but it does trigger a compliance rule. So you don't get off the hook just because something is worth less than $50. While the law doesn't prohibit us as public employees from accepting something that's worth less than $50, if by accepting the item of value, it creates an appearance of a conflict of interest, a disclosure is required in any instance where there is an appearance of a conflict of interest. Example, so I'm a school teacher, and the parents of one of my students have given me a $40 gift certificate to my favorite restaurant. I can accept it because it's not worth $50 or more. Does it create an appearance problem? Well, the answer to that exciting question is, it depends. Everything depends on the circumstances. If I were to get the gift certificate at the end of the school year, such that as a teacher, I would not have any further business dealings with the parents because that's at the end of the school year, that does not create an appearance problem. No disclosure is required. Because the appearance problem is not created when I accept or receive the gift certificate. It is created at that point after receiving the gift certificate, where I am next going to have official dealings with the giver. At that point, there's an appearance of a conflict of interest and a disclosure is required. So if I were to get the gift certificate from the parents at the end of the school year, I can accept it, it's less than $50, no disclosures required with my appointing authority, the school principal.
I have a question for Leah.
Okay, Leah, go ahead.
So this is the question on the ethics training that we do, the online training, that always frustrates me a little bit because, and I'm sure you're going to explain it a little bit more, but it's the question always about, can I accept the whatever $40 Super Bowl ticket? And I mean, it's actually, I mean, you could consider it a trick question, but in my opinion, football means not a whole lot to me. So I don't value even a Super Bowl ticket as like other people do. So I just think those types of questions aren't really, like you said, it's supposed to make us think, but on the basis of what we're being told all the time, you can accept a $40 ticket, even if it's to the Super Bowl.
Sure.
Now you're asking me to be judge and jury on how much other people value that.
Absolutely. So we'll get into that. Thank you for that question. It does get tricky, and I can tell you, this is not just an exercise to, to get your mind to work. Everything that we teach is based on actual enforcement cases. And so when we talk about whether you can accept a Super Bowl ticket that has a $40 face value on the ticket, we're going to explain how the commission interprets the actual value. It doesn't matter whether you're a football fan or not. If somebody gives you a ticket to a Super Bowl game with a $40 face value, and you were to go onto the secondary market to try to buy that same ticket, whatever that cost would be is the value of what was given to you. And that's the important thing. And I'll talk about that in just a little bit. That is a good question, but we're not trying to aggravate you. We took the most common enforcement matters that we've dealt with over the decades, and we incorporated it into our training. Oh. Okay, we'll get into it in just a little bit as we move further. I'm sorry? Okay, so moving on. So if you receive something worth less than $50 from somebody where you are going to continue to have official dealings with the giver, that triggers the appearance problem. So in my example as a teacher receiving a $40 gift certificate from the parents of one of my students, if I were to get that gift certificate in the middle of the school year, where I am going to continue to have dealings with the parents, then before I next have dealings, after I get the gift certificate, I'm going to need to have a written disclosure filed with my appointing authority, the school principal, that I got that gift certificate. Now, when public employees call us about this section of the law, we explain it to them as I've just explained it, but we also say, check with your town or check with your agency. If they have a policy that is more restrictive than the conflict law, that is what's going to apply. For example, the conflict law says I can accept anything less than $50. I might have to file a disclosure. But if I work for Massport, a state agency, they have a agency policy that says no Massport employee can accept any item of any value from anyone that has any remote dealings with Massport. Doesn't matter what the conflict law says. If the town has such a policy, that is what controls. And so when public employees call us for advice under this section of the law, we tell them, check with your agency. Yes?
How does, if, for instance, a general manager of a contractor periodically comes in to check on their project, and they typically come in once a quarter, and in that visit, they want to take you to lunch. First lunch is well under 50, not an issue. Second lunch, third lunch could very easily.
Very good.
that low.
See, you're dialed in. What he's talking about is,
a question for people at home.
sure, so just to repeat the question. So say somebody that you have dealings with wants to take you to lunch, and they take you to lunch and your part of the lunch costs $20. Can you accept it? Yes. because it's not something worth $50 or more. It will be something that will require a disclosure, however. You're gonna have to tell the boss in writing that the vendor that took you to lunch and paid $20. What the gentleman's question was about deals with what we call aggregation. Even though you can accept something that's worth less than $50 without violating the conflict law, multiple occurrences from a single source can be aggregated by the commission. And in the aggregation, if it gets to $50 or more, it then becomes a violation. So the gentleman was referring to the general manager of a vendor entity checking on their project with the town, and they do it quarterly, and each time they come in, they take the project manager, the town employee, out to lunch, and it's $20. Well, the first instance, $20, it's okay, a disclosure is required. In the second quarter, another lunch is $20, the aggregate is $40, it's still okay, another disclosure is required. Third quarter, no. Then we're over $50, it then becomes problematic. So multiple occurrences from a single source, and we use a 365-day window. Within a 365-day period, are prohibited. That means that if somebody provides you with something that's worth less than $50 and it's not the first time they've done it, you've got to look back. When did they last do it? If it's within the past year, then aggregation applies. If it's beyond a year, then no aggregation applies. Our advice is don't accept items of value from people that you're doing business with. Even if you're complying with the conflict law because you understand the nuances, doesn't mean that everybody else looking at it is going to come to the same conclusions. And situations frequently blow up even when people are complying with the conflict law, because people are free to form their own opinions, and a lot of times they get the wrong idea. Question?
But you could still go to lunch.
Sure.
You have to pay for yourself.
That's right, you just have to pay for yourself. And reciprocity is gonna be allowed. The whole intent on the conflict law are items of value given to you for your personal use. In a reciprocity, so this first quarter, they took you to lunch and it was $20, you're okay, you have to file a disclosure. Next quarter, you take them to lunch. Then you've offset all of that, so you don't have to do the look back because it was the offset. So reciprocity, so that you're not to the plus by any amount. It's an equal sharing, then you're going to be okay. Are there other questions about that? Okay.
If you have any questions from Zoom, turn on your microphone and ask.
So on this slide, these bulleted items are the common types of issues we deal with at the Ethics Commission. Public employees accepting meals from people that they're having dealings with, event tickets. And this goes to the lady's question about a $40 ticket to the Super Bowl. You see a reference to event tickets, advisory 04-1, right on this point. Back in 2004, the commission issued an advisory. An advisory is just generalized legal advice, where outside of the normal process where somebody calls our office for advice, the commission said, we've got an uptick in these situations. We better let the public, the world of public employees know generally how the law applies. Now, what was going on in 2004 that might have resulted in some uptick in activity with the commission? Patriots and Red Sox. You know, for those of us that have been following those teams in the years prior, never in my lifetime did I think I would live to see the day where they would win. And they both won. And public employees, you know, we don't have the season tickets necessarily, but we hang out with the people who do. Those vendor entities, the big firms that have contracts with multiple municipalities, outside consulting firms. Big firms, they usually have season tickets and they maintain those for a variety of purposes. One of them being for marketing purposes for their clients. What do private businesses do to build business opportunities? They try to get to know their clients. They want to get off the job and make it personal. That creates an outside interest under the conflict of interest law, where somebody wants to step outside of your normal public employee applicant relationship and they want to make it personal. So the commission issued this advisory because we were getting calls from public employees saying, I've been offered, I've been given, can I go? And so the commission explained $50 or more, you can't go. it violates the conflict law. And so after they got done crying, then we got into the whole issue of how do you establish the value to a ticketed event? So take out the Super Bowl. It's not a $40 ticket to the Super Bowl. It's a $40 ticket to Hamilton. If that's the actual value to attend the event, it's less than $50, it's okay. The problem is when you're talking about tickets to coveted events, where the demand for tickets far out exceeds the supply of tickets, what happens? Value goes up. And so the commission in the advisory said, as to event tickets, be it sporting events, theater, you name it, but to ticketed events that are coveted, where the demand for tickets exceeds the supply of tickets, we're not going to necessarily use face value to establish whether something is worth $50 or more. We're going to use actual value. And it's easy enough to do today by getting onto the secondary market to see what a comparable ticket will cost you. And for a coveted event like the Super Bowl, like a theater production such as Hamilton.
Taylor Swift.
Exactly. Still waiting for my no.
Army baby.
Yeah, whatever. Sometimes the events, they don't draw flies. You know, you could look at some of the football games and I'm looking into the stands and there's nobody there. So a $40 ticket is going to be less than $40 because you could, you know, go out to the scalpers outside the stadium and pick up the same ticket for $10. So that's not going to be a problem. But, you know, where there's a sellout and the scalpers are selling tickets, it's generally going to be, you know, 5, 10, 20 times what the face value of the ticket is. And so the only point in that question is to say that, you know, don't assume that face value to a ticket is the actual value to attend the event. And we had actual situations. You know, we had state inspectors. Now, the state owns property, and sometimes those properties have to be renovated. We don't have state contractors ready to do that work. We contract out with private contractors. They do the work, state employees inspect. And we had situations where the contractors were offering tickets to these state employees, and we had to go through all this. We've had some where they were given Red Sox tickets out, and we investigated. You know, these inspectors accepted Red Sox tickets. They were worth more than $50 or more, and they violated the conflict law. Now, we had such a case where we investigated and established the facts, and we determined, yeah, this was a violation of the gift restriction rule. But, you know, in full investigation, was there any effort to undermine the work of the inspector? Did any corners get cut? And we found out, no, everything was on the up and up, and it was just a one-off kind of thing. Project went on for a couple of years. It was just one instance of a ticket. Everything was done fine. So we said, yeah, there's a violation, but we're not going to take enforcement action. You know, there wasn't an egregious enough violation in our view to warrant enforcement action. So we went away and we sent the inspector and the vendor confidential letters saying you violated the conflict law. When the state employee went back to work, he then got fired. Even though we declined to take enforcement action, that doesn't mean the agency isn't going to have something to say about it. And the agencies have a right to decide whether they think the conduct is egregious enough to warrant action. And so that's the point where accepting tickets, it's not something that we pull out of the air. We deal with it, not all the time now. People, you know, they get the message for the most part, as far as we know. And we don't hold out any notion that we're up to speed on all the conflicts of interest that are happening in the world today. But in situations where public employees are accepting tickets, you know, we've got enough precedent where we're going to know how to proceed. Okay, so these bulleted items, you know, these are the types of things we deal with. Travel and expense reimbursements, gift certificates, floral arrangements, and fruit baskets for those who might oversee vendors. Not uncommon where the vendor might send a floral arrangement every once in a while or a fruit basket. Lottery tickets. Let me give you a quick quiz. So you're in town hall and somebody who only knows you as a town employee comes up to you one day. It's a holiday. Everybody's feeling jovial. And they hand you a $50 scratch ticket. Can you accept it? No. It costs the giver $50 or more. It's prohibited. What happens if you succumb to the temptation and you scratch the ticket and it comes up goose eggs? It still costs the giver $50 or more. It's prohibited. But what, however, if they come up to you and hand you a $2 scratch ticket? Can you accept it? Yes, it's not $50 or more. What happens if you scratch it and you win $10,000? It's your lucky day. It only costs the giver $2. But will that situation create an appearance problem necessitating a written disclosure with somebody? Probably, depends on the circumstances. But it's just, everything depends on the circumstances. Gifts offered through sales promotions. In my younger days, I was part of an enforcement team, and one of our cases involved a food services director in one of our school districts. Now, the job of the food services director is to manage a budget. And that's important, especially when their resources are finite and you've only got so much money to spend. Now, this food services director deals with food wholesalers. And what do they want to do? They want to sell food. So you've got this, confluence where you have people that want to move as much product as possible going up against the gatekeeper managing the budget properly. Now, the food wholesalers were offering inducements, as people in sales frequently do. They want to increase sales by offering inducements. So these food wholesalers were offering iPods, for those of us that can remember back that far, the Apple Music devices. And so this food services director thought, geez, these iPods would make great gifts for the grandchildren. So rather than manage the budget, ordered enough to qualify under the inducement on several occasions. Now, who owns those iPods? The town. It's their budget money that bought the food that qualified for the inducement. Maybe the library, the school library, could have made great use of those. It didn't occur to the food services director that you don't get to not manage your budget appropriately so that you can get iPods to give to your grandchildren. So not only when we found out about it did we investigate and the commission imposed a penalty for her violating the conflict law, rather than serving the public interest, she instead made decisions based on her own personal interests and wants. And not only did the commission sanction the person for violating the conflict law, what happened when she went back to work? She got fired. Those are the ramifications. So you've got to be careful about that stuff. So there are regulations. I talked about the restrictions. Gifts where there's a quid pro quo prohibited, gifts worth $50 or more given to a public employee by someone with whom they have official business dealings prohibited, gifts worth $50 or more given because of public position. Question?
This may be splitting hairs, I apologize ahead of time. If somebody brings you a fruit basket, as a thank you, whatever during the holidays, you accept it, but you turn it over and you open it up to allow the entire department to partake of it. So it's not just for you, but for your entire group. How does that handle?
That's doable based on what you've just said, because we have regulations where we recognize that some situations, although they implicate the gift restriction rules because some item valued at $50 or more is being conveyed, but where we can eliminate any conflict law mischief, it's going to be allowed. These bulleted items here constitute exemptions from the gift restriction rules. And I'll talk about what you're saying. The unsolicited perishable items is right on point with what you have. But these ones here, travel expenses, the ability of public employees to attend training or other legitimate town business travel and have a private entity pick up those costs instead of the town. The commission has said there's a real benefit to the public by allowing that. Does the public benefit by you attending additional training to be better trained in how to do your job? Absolutely, there's a benefit to the public. Does the public benefit where the public doesn't have to spend its money to get you that training because some private entity is willing to pay for that? Yeah, there's a definite benefit to the public. And so by regulation, the commission has said, where there is travel and where expenses are incurred, where the travel is legitimate, training, informational, business, what have you, public employees can have their expenses paid, prepaid, discounted, what have you, without violating the gift restriction rules of receiving something worth $50 or more given because of public position or by someone with whom they have official dealings. Provided that they follow the regulation, which is the public employee files a disclosure with their appointing authority. The appointing authority then has to make that determination. They have to review the situation and say, yes, this is legitimate. The employee traveling in connection with this event, be it training, be it business, serves a legitimate public purpose. The disclosure is a public record, it's in writing. The agency is managing the process, because it's aware of the situation and has decided that this is okay, and then it's allowed by regulation. So let me just stay on here. So we have exemptions that also apply to incidental hospitality. You attend a meeting with a vendor and they're always providing lunch, pizzas, or what have you. Public employees can accept those items, again, as long as they file a disclosure with their appointing authority to put their agency on notice. Hey, we're at this meeting with the vendor and they provided us with lunch, pizzas, and what have you. And the appointing authority says, okay, yeah, that serves a legitimate public purpose. Public employees can accept hospitality. Really, it's to sort of keep the questions from coming, because we would get these questions all the time. I was at a meeting with the vendor, there's a whole bunch of us there, and they had coffee and pastry. Do I have to find out how much a muffin cost to verify I didn't get anything worth $50? It gets kind of ridiculous. And so by regulation, it's no, you can accept food and beverage as long as the meeting itself, the event itself serves a public purpose, and you disclose it publicly to your agency via your appointing authority, and they then endorse it by saying this serves a legitimate public purpose. Unsolicited perishable items deals with the gentleman's question about a fruit basket or a floral bouquet. Now, the presumption is a floral bouquet or an edible fruit basket is going to cost more than $50 or more. The delivery charge is going to get you up there to start. And so they implicate the gift restriction rules. But perishable items are perishable items. It's impractical to refuse or return those. And there's not a lot of harm in a public employee accepting a floral bouquet. Nobody's attempting to bribe a public employee with a bouquet of flowers or an edible fruit basket. Those are just efforts by people to say, thank you, appreciate working with you, what have you. Yes, they implicate the gift restriction rules. Yes, there is a concern about whether public employees could be improperly influenced by accepting those items. But by regulation, the commission has said, as to perishable items, as long as they are unsolicited by the public employee, even though they cost $50 or more, they can be accepted as long as the public employee does not accept it for their own personal use. Instead, they accept it on behalf of their agency, and they demonstrate that by sharing the items with everyone at the agency. And it takes out the conflict law mischief. The conflict law mischief involves gifts provided to you for your personal use, and where you're following the regulation. So say you're dealing with a vendor on a vendor project, and it's a long project, and out of the blue, they send you a floral bouquet. It's going to cost the vendor $50 or more, so it implicates the gift restriction rules. Under the regulation, you can't accept it for your own personal use. So when it comes from the vendor, it doesn't go in your office and you don't get to take it home. It goes out in the lobby, some publicly available area, so everybody can enjoy the flowers equally. The edible fruit basket comes in, I say you get a little bit of wiggle room. You take it to your office, grab the chocolate-covered strawberries out of there when nobody's looking, and leave the apple slices and the pineapple for everyone else, as long as you're accepting it on behalf of the agency and you're sharing the items, then it won't violate the conflict of interest. We have other exemptions, passes to school events where the district is providing passes to, if the drama club is having their annual theater off or whatever they do, or there's some other school event and the school district is providing free tickets or discounted tickets to school staff. Those kinds of things are allowed. Class gifts to teachers. Recognizing that, especially at the elementary school level, parents want to provide meaningful gifts to the teachers to say thank you for the services they're providing to educate their children. And so the commission promulgated a reg that says, while the rest of us have this $49.99 limit, we're going to allow teachers to accept class gifts of up to $150. Now, when I say a class gift, that means people are pooling their resources. Now, the regulation says that a teacher can accept a class gift of up to $150 as long as the individual contributors to the class gift are not identified to the teacher. Why? So that the teacher is not put in a position where they could be improperly influenced. They don't know who contributed. The regulation also requires that if a teacher accepts a class gift, and then a parent separately provides a gift of up to $49.99 to the teacher has to ask that parent, did you contribute to the class gift? Because you cannot do both. And then also this regulation provides that we can donate gift cards of up to any amount to a teacher, where the intent of the gift card is to reimburse actual classroom equipment and supplies, recognizing that teachers frequently go out of pocket for that stuff. So I could go to Staples and buy a $200 gift certificate and give it to my child's teacher, where the expressed intent is reimburse actual equipment and supplies. And we tell teachers, if you get one of those, save your receipts, because we reserve our prerogative to verify through the receipts that nothing went to you personally, that all of the expenses were for needed classroom equipment and supplies. Gifts amongst public employees. By regulation, I can give a gift worth more than $50 to one of my colleagues. I'd be giving it to them because of who they are as a public employee, but it's allowed under the conflict law, with the exception, gifts from subordinates to managers are restricted. The commission views those circumstances as inherently coercive. So only a gift of nominal value, handmade gifts, baked goods, can be given from a subordinate to a manager. But for colleagues and where there is no manager-subordinate relationship, we can give gifts to other public employees that are valued at $50 or more. Okay, that concludes our presentation on the gift restriction rules. Any questions on that? At home or live? Okay, we'll move now to the nepotism rules, and that was bucket one when I began. Bucket one, nepotism rules, financial interest conflicts. The conflict of interest law says for municipal employees, you may not perform your duties. You may not participate in official matters if certain financial interests are affected. Number one, the employee, yours. Also, the financial interests of your immediate family members. Also, the financial interests of any business that either employs you privately or that you own or operate, or the financial interest of any business partner that you might have, or the financial interest of anyone or any entity with whom the public employee is negotiating for employment. If I'm overseeing vendor performance on a vendor contract, I'm the town employee assigned to oversee that vendor. And then there's a job opening with that vendor entity that I want to apply for. I want to move on. And so I apply for the position, I get interviewed, they like me, and I move up to the point where we're now talking about me going to work for them. We are negotiating the terms of my prospective employment with them. Can I, as a town employee, continue to oversee that vendor contract where I'm also negotiating for employment with the vendor? No. Classic conflict of interest. There is a workaround, recognizing that not all financial interests are significant. Sometimes it's insignificant. Sometimes a financial interest conflict occurs in connection with some routine administrative matter. So the basic restriction is, hey, where are you going? Get back there. Oh, no problem. So the basic restriction is, when you encounter a financial interest conflict, you have to stay out of the matter. You have to abstain or recuse. But there is a workaround for state, county, or municipal employees, but it works a little bit differently for state or county employees. But for municipal employees, you have an option. You know, if the financial interest is insignificant and you feel compelled to want to continue to participate in something, even though you have a financial interest, you may be able to. If you file a written disclosure with your appointing authority that you have this financial interest conflict, and your appointing authority says it's okay for you to continue to do your job, the language, the statutory language is they have to make a determination on your disclosure form that the integrity of the services that they can expect from you are not going to be affected by your handling the matter. Now, why would that come up, or how would that come up? Well, a typical case could be that of, say I'm a department head, and one of the things I have to do as a department head is certify the payroll for my department. And I happen to have an immediate family member who works in my department. An immediate family member would be a brother or sister, a spouse, or a child, or a parent. Now, I didn't hire them to work in my department. That's a significant conflict violation, and I don't supervise them the same. When they were hired into the department, I wasn't the department head. And then I got the promotion, and now I'm a department head who has an immediate family member working in my department. And one of the things I have to do is certify the payroll for my department once every 2 weeks. I'm required to do that to comply with municipal finance law. Now, what does certifying the payroll constitute? This. I'm presented with the payroll, prepared by staff, and I sign off on it. That's the extent of my participation. But if I sign off on it and I have an immediate family member working in my department, that means they get paid. So that's participating in a matter that affects their financial interest. If I don't sign off on it, nobody gets paid. That's not a workable solution. And so the conflict law has this workaround that says, while I'm required to step back from certifying the payroll if I have an immediate family member in the department, I can pursue this disclosure determination workaround process. I can file a disclosure with my appointing authority, say it's the town manager, town administrator, board of selectmen. They look at my disclosure and they can decide what to do about my situation. They can either take responsibility for certifying the payroll and handle it themselves. They can assign the duty of certifying the payroll for my department to someone else, or they can make that determination that my certifying the payroll, even though it affects the financial interest of my family member, is not a significant enough financial interest so as it would affect the integrity of the services that they can expect from me. Collective bargaining. I mean, I don't know how it is around here, but let's say in the smaller towns in the Commonwealth, you have a lot of people with the same last names working in the same department. You could have a police chief who has a son or a daughter who's a police officer, or a fire chief and what have you, and collective bargaining comes around. Are the results of collective bargaining something that's going to affect the financial interest of the family member working in the department? Yeah. When you're talking about collective bargaining, you're talking about management and labor getting together and hammer out a deal. If I'm the department head, I'm the police chief or fire chief, and I have the family member in the department, I can't participate in collective bargaining. It's a financial interest conflict. I've got to stay out of it. But if I do, it arguably puts, one half of that equation, the management side, at a competitive disadvantage. Because the department heads informed that whole process. They know best what's going on within the department. So that's a situation where collective bargaining goes on. I have to stay out of the matter, but I can file the disclosure with my appointing authority that I have to stay out of the matter because it affects financial interest. They then get to decide whether I can continue to participate in collective bargaining. Bottom line, under the nepotism section, I cannot handle matters if certain financial interests are affected unless the boss, in writing, says it's okay, using that disclosure determination process. If I'm elected, I don't have an appointing authority. So if I encounter a financial interest conflict, I've just got to stay out of the matter because I can't go through that disclosure determination process. So immediate family, under the nepotism section, I cannot perform my duties if what I will do will affect the financial interests of me or an immediate family member. The term immediate family is defined in the conflict law in section 1, which is the definition section, and it's reflected on this chart. As you see in the chart, I'm a member of my own immediate family. So it's myself or you, it's your spouse if you have a spouse. It's your siblings and your spouse's siblings. It's your parents and your spouse's parents. It's your children. Those are your immediate family members. You cannot perform your town duties if what you will do will affect those financial interests. Now, what about other relatives you might have? That question comes up. What about other family members who are not immediate family members? Let's call them non-immediate family members. And who are they? Cousins, aunts and uncles, nieces and nephews, grandparents, grandchildren, ex-spouses, domestic partners. Not on the chart, not a nepotism issue. Because a necessary element for a nepotism violation would be a member of the public employee's immediate family. But that doesn't mean the conflict law doesn't apply. It's just which section applies. And I talked about the two buckets. If something is not a nepotism issue because the person is not an immediate family member, that doesn't mean the conflict law doesn't apply. It just means it falls into that second bucket. If I were to award a contract to my cousin's company, is that a nepotism issue? No, because a cousin is not a member of my immediate family. But is that an appearance of a conflict of interest? Most definitely. So if it were to award a contract to my brother's company, I have to stay out of that. It's a nepotism issue. If it's award a contract to my cousin's company, I can continue to perform my duties because it's not involving an immediate family member, provided I first disclose that relationship with my appointing authority. Now, if my appointing authority is properly dialed in and I file that kind of a disclosure with them, hopefully they're going to step in and say, don't want you handling matters affecting the financial interests of anybody you know, let alone whether you're related to them. And that's the conflict law allows the agency to manage conflicts in the best interest of the agency. Even though the conflict law says I can do this, if my agency says no, then the answer is no. And so examples under the nepotism section, hiring or promoting family members, approving overtime, pay raises, preferential work assignments, anything that might involve financial interest, overtime opportunities, comp time opportunities, intervening in disciplinary matters involving family members, certifying payroll, participating in contracts, budgets, grievances, etc., or participating in matters affecting a private employer. These can all implicate the nepotism section of the conflict law. We have some regulatory exemptions I just want to touch on briefly. It gets kind of weird if you're a school committee member or if there's a local charter school and you're serving on the board of trustees and you're deciding policy matters. There's a lot of policy matters that affect financial interest. So if I'm serving, for the school committees, 90% of the school committees across the state, those members serve because they have children in the district. They've got a vested interest. Now, what happens if I have children in the district, I'm on the school committee, and we're now setting bus transportation fees and my kids take the bus? Is that participating in a matter that's going to affect my own financial interest? Yeah. By exemption, the commission has said, you're going to have 90% of these school committees unable to perform their duties or getting, bogged down in technical requirements. And so by regulation, the commission has said, as to school committee members or members of charter school boards of trustees, because charter schools are state agencies and those folks are state employees for conflict law purposes, they can participate in those policy matters, even if their own financial interests are going to be affected, as long as the financial interests are shared by everyone similarly situated. In other words, the financial interest is not unique and distinct to the board member, but rather it affects everyone, such as, athletic fees, transportation fees, meals, after-school activities, any of that stuff. So that's a regulation that's available for school committee members. And then exemption for board members appointed by a public agency. If I serve on I might just throw it out there, I serve on the planning board and the planning board has appointed me to another town committee to study, mooring issues, and I own a boat and I have a mooring or something like that. If I'm appointed by my public agency to another board, I can participate in general policy matters, again, even if my own financial interests are affected, as long as the financial interests of everybody similarly situated are similarly affected. Okay, rule of necessity. I don't know how in-depth we need to get here. What's our time? Well, we're doing okay, I think.
I think we're just about done.
Just about time. Look at you paying attention. Look at you. You finally opened your eyes. Welcome. I'm just teasing. He's been awake the whole time. So in any event, Rule of necessity applies only to elected board members. So, the rule of necessity allows an elected board that cannot put a quorum together to handle a matter, if they can't put a quorum together because a sufficient number of members have a financial interest conflict. Elected board members don't have an appointing authority. For appointed boards that can't put a quorum together because of conflicts of interest, those folks can pursue the workaround, the disclosure determination process. Elected boards can't. So there's something called the rule of necessity available to elected boards, and there's an advisory referenced on the slide, 0505. If this resonates at all, check out the advisory. I usually have a long explanation, but we're running out of time. And then also abstaining. We see different versions of board members abstaining. We see people saying, I'm abstaining, they remain at the table, I'm abstaining and they go sit in the audience, or I'm abstaining and they leave the room. Which one is accurate or correct? A, B, C, or D, all of the above? All of the above. The law says you can't participate. It then doesn't further prescribe what that means. But I just want to flag that because you want to think about whether you have any skin in the game. Because if a matter comes up and it affects your financial interest so that you have to abstain and you abstain but remain at the table, you're not doing everything you can to insulate yourself from a call to the Ethics Commission, and believe me, we get them. And even where you're not violating the law, we may still get a complaint that you violated the law because you were swapping hand signals, glaring, winking, nodding, what have you. And so when we get those kinds of complaints, we vet every complaint that comes in. You don't want to buy that kind of happiness. You want to do everything you can to protect your reputation and avoid somebody getting the wrong idea, which can frequently happen. So you can remain at the table and just abstain and take your chances, or you can abstain and go sit in the audience. Now, what happens if you do have skin in the game? Say you're serving on the elected planning board and Walmart wants to put in a big box store right next door to your property. Is that a matter that's going to affect your financial interest? Now, as a planning board member that's going to decide that matter, you cannot participate. That's a nepotism issue. But you don't lose any of your rights just because you serve on the planning board. You're still a voter, a taxpayer, and what have you. So you have to abstain as a planning board member, but you can go sit in the audience, and then when the public hearing process goes on, you can participate as a member of the public as long as you're speaking for yourself, and don't make the mistake of saying, well, me and my neighbors, or, referencing your board position by saying, Harry, at executive session, you said you were, then you're not representing your own personal interest, you're acting as a board member. But also, there are situations where people abstain and then leave the room. In a court decision, the decision said the wisest course of action when having to abstain is to leave the room. Now, the conflict law doesn't require that, so why would they say that in a court decision? Because when you leave the room, you remove all doubt. Nobody can come back and say you participated. You weren't even there. So I just say this for board members to just, look at these situations and understand how the public might view your conduct if you're required to abstain and they know it, and you make one of those choices. Did you have a question?
Yeah, I think you sort of touched on it, but I'm going to use of the Conservation Commission as an example. We live in Lakeville, and most of the members actually have wetland implications on or around their property anyway. So, for example, if you wanted to get a permit to do something in your own yard, but there were wetland implications, so you had to go through a conservation filing, is participation answering questions from the audience? You went and sat in the audience.
Okay.
And then the board had questions about your project that maybe you had more intimate knowledge than an engineer, so you felt compelled to answer them. Is that participation to the
That is, oops. So for the people joining remotely, if you're a board member and you have an application pending before your own board, are you free to answer general questions posed by the audience because you have an intimate knowledge about the process? The answer is it depends, but most likely no. One of the sections of the conflict law that we haven't talked about yet says you cannot represent third-party interests before the town. You have a duty of loyalty to the town when you become a town board member. And that means you can't compromise the duty of loyalty by representing a private interest. So when people pose general questions to you, the thing we would look at is your application filed on your personal behalf? Because if it is, then you're okay. But in most cases, it's not. There's an LLC or a corporation or an LLP that holds the property and interest in connection with the application. And if you're answering questions as a property owner where the property is technically owned by some third-party interest, that implicates the conflict law. So no, you can't. If you have to abstain, you can,
I'm saying you would abstain from the vote.
right, and then sit in the audience. But the question becomes, if you're then handling questions that would normally go before the board or would normally be answered by your designated representative, such as your attorney or an engineer, you got to let them do that, because if you do it, you might be viewed as representing some third-party interest before the town where the conflict law says you can't. Okay? Yes?
Can you touch on the difference between abstain and recuse?
There is no difference. In our world, those two terms mean the same thing. And I say that because in a different context, when you say abstain, that just means that you're present non-voting. But that's not when we say abstain or recuse, that means poised to participate, stepping back from participate. Those two terms mean the same thing in our world, although in a voting context, abstain might have a different meaning. Okay, we are almost out of time, so let me just burn through the rest of this stuff. The conflict of interest law contains code of conduct provisions. Bucket 2 that we talked about. I talked about appearances of conflict of interest and the need to file a disclosure whenever you have an appearance of a conflict. The conflict law also says you can't use your position, your town position, to secure any benefits for yourself or those people you're connected to privately that you are not otherwise entitled to receive. All town benefits are conveyed to people according to rules. When we perform our town duties, everything we do follows a process guided by a rule or a statute or a bylaw or an ordinance, so that we treat similar situations similarly. Under the conflict law, if a public employee deviates from the normal rules that guide how they're supposed to handle a matter, and as a result of that deviation, someone they're connected to privately benefits by $50 or more, that's where the second place in the law where the $50 rule applies. It's a violation. If I issue a permit as a town employee and I charge everybody a fee for the permit except my friends and relatives, well, guess what? I'm improperly using my public position to convey benefits to my friends and family that they're not entitled to receive. Improper use of public position. Disclosing confidential information. Who is that? That was me. So disclosing confidential information I want to touch on. If you as a town employee, your board would have it, if you review or receive confidential information, you may not improperly disseminate confidential information to anyone not authorized to receive it. If you do so to further a personal purpose, that violates the conflict law. This restriction applies whether you're a current town employee or a former town employee, because the commission operates under a 6-year statute of limitations. If a town employee learns confidential information, they then leave their town position. And then a couple of years later, they improperly divulge that confidential information to further a personal purpose, it is still actionable by the Ethics Commission. We're about out of time, so there are a couple of great things that I'm not going to be able to cover. And boy, these are really important things, but what the heck. You've got the slide deck. I want to say that just if you need to leave, feel free. You won't hurt my feelings.
Can you just explain to them the importance of taking the ethics test?
Oh, sure.
It's not an option.
Oh, absolutely. So in 2009, the conflict of interest law was amended to include mandatory education, a recognition by the powers that be that just turning someone loose on the public as a town employee was not sufficient. There are some statutes that guide what they can do that are fairly complicated, like the conflict of interest law. So the law said all public employees have to complete an online training program provided by the commission within 30 days of appointment or election, and then every 2 years thereafter. And then annually, all public employees have to be given by the town the summary of the conflict of interest law, and the public employee has to acknowledge to the town that they received that summary. This is not optional. If you are a public employee, you will complete those requirements. Now, we're pretty easy with compliance. We're not hard and fast on deadlines. As long as people are making good faith efforts to comply, we're okay with that. But if I learn that somebody is willfully refusing to complete those requirements, then it's going to become an enforcement matter. The commission will take enforcement action. The commission, we have one case, and I feel bad because in my 12 years of administering the process, when I've called somebody to explain their legal requirements, they went ahead and did it. But we had one guy that chose to ignore all of our calls, letters, emails, what have you. And then he resigned from his planning board position and submitted the compliance records. Well, we had been telling him, where are your compliance records from 2018? Where were your compliance records from 2019? I don't care at this point that you've resigned your position and you're giving me something that's dated in 2020 or 2021. The commission issued a civil penalty of $2,500 to an unpaid planning board member for willfully refusing to complete those requirements. And so we talk to town clerks or those agencies that administer the process for our public agencies. And if we learn instances where people are not completing the requirements, then we will intervene. We'll ask the town to do their part to send out notifications. All we care about is that people are making reasonable efforts to complete the requirements. You know, it doesn't have to be hard and fast on a day. We understand people are busy. We understand the added burden this might impose. But this is important stuff. The conflict law restricts or regulates what you can do. And it's important to maintain the public interest, to make sure that the public knows that public employees have received appropriate training on all of the laws that guide what they can do. Are there any questions on any of that stuff? Any blowback or anything like that? I'm fine with it. That's okay. So I think we'll wrap up now. I just want to give you a preview of those things that we were going to talk about. We've run out of time, and that's okay. We get through what we can get through, but just so that you can ooh and ah. And if you have any questions, I'm available until the next presentation. But there are sections that apply to us when we're not at work. The duty of loyalty based on the gentleman's question. When we're not at work, we can't represent third-party interests before town boards. We can't be hired and paid. We had a case involving a Conservation Commission member who decided in order of conditions and then was hired by the developer. After he participated in the order of conditions, the developer hired this Conservation Commission member to do the excavation work in connection with the permit that he just issued. And so that violated the duty of loyalty requirement that the conflict law imposed on that person. There are also provisions in the conflict law governing special municipal employees. For you board members, chances are your position has been classified as a special municipal employee. What that means is if you have existing business interests with the town and you then become a board member, you can continue to have those business interests. If your particular position has been classified by the town as a special municipal employee position, and most of them have by this day and age. If I were to sell insurance to the town, and then I were to be appointed to I just keep using planning board, I'm sorry, but the unpaid planning board, the conflict law under the duty of loyalty requirement says, if I'm a town employee as a planning board member, I can't then sell insurance to the town unless planning board members have been designated as specials. What the designation does, it says, I can continue to do business with any town department, board, or agency, just not the planning board, just not the board or department or agency that makes me a town employee. So those are some of the other restrictions. So you've got the slide deck. Just look through it. If you have any questions, reach out. And maybe we'll cover it in the 6 o'clock presentation, so you're welcome to stay. Who is assigned to provide treats? Do we have? Oh, the guy didn't show up. We ordered it and it's supposed to be here, but he never showed up. So that's basically it. Thank you for your kind attention, and if you have any questions, call us, okay?